PGA Tour v. Martin, Antonin Scalia's most entertaining dissent. In 1997, golfer Casey Martin sued the PGA Tour for not allowing him to use a golf cart at tournaments. Martin suffered from a circulatory disorder that made it extremely painful to walk. He cited the Americans with Disability Act as legal reasoning, which requires public accommodations to make reasonable modifications in order to allow disabled customers to use them, unless such modifications would fundamentally alter the nature of such accommodations. By 2001, the case had made it to the Supreme Court for review. The Supreme Court had to decide whether the ADA required the PGA Tour to accommodate professional golfers with disabilities, and whether using a golf cart would fundamentally alter the game at a tournament. The court ruled in a 7-2 decision in favor of Martin, asserting that under the ADA's basic requirement that the need of a disabled person be evaluated on an individual basis, we have no doubt that allowing Martin to use a golf cart would not fundamentally alter the nature of petitioners' tournaments. Justice Antonin Scalia, joined by Justice Thomas, dissented in one of the most entertaining and quotable opinions. He clearly expressed the difference between what the law requires, the purview of the court, and what might be fair or decent, but not required. In my view, today's opinion exercises a benevolent compassion that the law does not place it within our power to impose. The judgment distorts the text of Title III, the structure of the ADA, and common sense. Scalia takes issue with the majority's argument about the fundamental nature of the game. It has been rendered the solemn duty of the Supreme Court of the United States to decide what is golf. I am sure that the framers of the Constitution, aware of the 1457 Edict of King James II of Scotland, prohibiting golf because it interfered with the practice of archery, fully expected that sooner or later the paths of golf and government, the law and the links, would once again cross, and that the judges of this august court would someday have to wrestle with that age-old jurisprudential question for which their years of study in the law have so well prepared them. Is someone riding around a golf course from shot to shot really a golfer? The answer, we learn, is yes. The court ultimately concludes, and it will henceforth be the law of the land, that walking is not a fundamental aspect of golf. Either out of humility or out of self-respect, one or the other, the court should decline to answer this incredibly difficult and incredibly silly question. To say that something is essential is ordinarily to say that it is necessary to the achievement of a certain object. But since it is the very nature of a game to have no object except amusement, that is what distinguishes games from productive activity, it is quite impossible to say that any of the game's arbitrary rules is essential. Justice Scalia made it clear that his objection was not about the handicap of the plaintiff or the relief that he sought. My belief that today's judgment is clearly an error should not be mistaken for a belief that the PGA Tour clearly ought not allow respondent to use a golf cart. That is a close question, on which even those who compete in the PGA Tour are apparently divided. But it is a different question from the one before the court. Complaints about this case are not properly directed to Congress. They are properly directed to this court's Kafkaesque determination that professional sports organizations and the fields they rent for their exhibitions are places of public accommodation to the competing athletes, and the athletes themselves customers of the organization that pays them. It's Alice in Wonderland determination that there are such things as judicially determinable essential and non-essential rules of a made-up game. And it's Animal Farm determination that fairness and the ADA mean that everyone gets to play by individualized rules, which will ensure that no one's lack of ability, or at least no one's lack of ability so pronounced that it amounts to a disability, will be a handicap. The year was 2001, and everybody was finally equal.